Hi, everybody. I am Amber Finch of Finch Real Estate Company, and this is Peggy Hoyt of the law offices of Hoyt and Bryan, and she is an estate planning attorney and here to answer some questions for us today. So thank you for joining us, Peggy.
It's my pleasure.
Good. I'm so glad that you could come at us from home. I know we're all going through what we can through the coronavirus epidemic. And I'm glad that you can join in. It's lovely that technology is among us so we can do things like this.
I think we're all getting better at technology as a result.
Yeah, I would say that is one positive, right? We're all learning how to do things virtually and take it to the next level where we can. So are you seeing that you're meeting with clients like virtually like this, or how are you doing your meetings?
We are doing that. So clients that want to still have a meeting, we're doing them by Zoom, we're doing them by telephone, and for those that need to do their signings, we're having a little bit of fun with that. We're doing what we call parking lot signings. So people are pulling up in their cars and we're coming out, bringing them their documents. They're staying in their car safely, and the team is able to witness the signatures, and we do the notarization, and then they wait in the comfort of their car while we run back in and process all documents.
It's crazy how we're kind of changing the way that we do things, and I see that this will affect everybody's business practices in the future. So it's really cool.
Well, and it may give us all a little more flexibility too. So where people start to get used to maybe doing things virtually, it will maybe open up opportunities for people to connect with more people.
Yeah, that's true. That's good. So tell me a little bit about yourself. We have some background noise. Hold on one second. Let me make sure. Okay, I don't know where the feedback is coming from, but hopefully we don't continue to get it. All right, so tell me a little bit about yourself and how you got in as an attorney for estate planning.
Well, I often describe myself as an estate attorney, animal advocate, and pet mom. So that's kind of my background. I started out in financial services as a financial advisor and really loved the field of estate planning. So I was actually one of those lawyers that when I went to law school, I knew exactly what I wanted to do. I wanted to do estate planning, and then ultimately I learned to do the elder law practice as well. And Randy, Bryan, and I have been in partnership for over 20 years now, serving the Central Florida community. And we really see ourselves as educators more than anything else. And one of our mottos is that we teach you the questions that you didn't even know that you needed to ask. So that's kind of fun for us. So we like being educators. When I'm not being a lawyer, I am advocating for animals in the animal welfare world. And I am a pet mom. As my radio podcast says, all my children wear fur coats. So I have 3 horses and 6 dogs and 2 cats.
Oh, that's one thing I love about you is you are definitely an advocate for the animals. So thank you for that. And something that you taught me, I learned a little bit about following your company, was that you can actually do a will for your pets, and you help people do that.
Yes, pet trusts are valid in all 50 states and the District of Columbia. And I spend a lot of my time encouraging pet parents to make sure that their pets are taken care of in the event something happens to them. And even created a not-for-profit organization called Animal Care Trust USA to help in those endeavors.
Oh, that's amazing, because I think that some people really do have those fears. I mean, you have your pets, your loved ones, and if something were to happen to you, what would happen to them, right? So where do they go? What happens? So
definitely, and a lot of us have seen on Facebook recently posts from people that say, this person passed away or this person became disabled, and we need help placing these dogs or this cat or even horses. So I think it is a good idea for everybody who is a pet lover to make sure that they include their pets as part of their plan.
Yeah, I agree. So you just talked about how you like to educate people. So that's what we're going to do today. I know that, you know, you never know what you don't know. And there's always questions out there. And I'm sure you guys get an onslaught of frequently asked questions that are asked repeatedly over and over again. I get people that ask me, you know, questions when someone passes away, you know, what are they supposed to do? You know, and obviously that's more of the law side of things that I'm not really directing them to, but I have a basic knowledge. So you're here to not only educate our consumers, but give me a little bit more information. So I look forward to learning a little bit more. Could you kind of help us? I know estate planning is a pretty broad topic. So can you tell us a little bit about what entails under estate planning?
So estate planning is a broad topic, and different industries use that term differently. So from a legal perspective, estate planning is really the creation of those legal instruments or documents that are going to address what happens if you're unable to make your own decisions, who can be your decision makers, and then also what would happen in the event somebody were to pass away and how they want their assets distributed. And there's a whole lot of ways to make distributions of assets. And of course, one of the things that we always want to avoid is any kind of family conflict if we can. So when we're working with families, we really try to get to know the family dynamic so that we can understand how well people play together, and whether or not we can make some suggestions to try to avoid potential conflict in the future.
Yeah, and I think that's really helpful, because I think unfortunately a lot of families do go through conflict because they aren't prepared of, you know, if let's say a parent passes away, a lot of the siblings are now, you know, in some type of turmoil. So I think that having those necessary documents to lay out exactly what the parents' intentions were with their assets are helpful. So that's a good idea. So besides people that maybe are elderly or those that have lots of money, right? Who else should be doing estate planning for themselves?
Well, that's a great question, because when people hear the word estate, they automatically assume that you got to have an estate. Yet every single person has an estate. Everything you own is considered to be part of your estate. So whether it's a little or it's a lot, it's part of your estate. And so we encourage people of all ages. So we don't think estate planning is just for the old or people that are infirm. It's really for everybody, because I am fond of saying that if you don't create your own estate plan, the state of Florida has one for you. And it may not be the plan that you would have crafted for yourself.
Yeah. I mean, I see that often, that, you know, people end up in that situation and then they're upset with what the state designates. And unfortunately, there's really no control over that if somebody didn't prepare for, you know, their death, unfortunately. So I know that there's different terminology thrown around when in terms of how do I, you know, put it in writing. What do I do? I know we've heard the word will, and we've heard people say trust before. So can you tell us what the difference is between a will and a trust and how those might help you?
Sure. So everybody needs a will. A will is basically your final expression of how you want your assets distributed. Some people will want trusts in addition to wills, and a trust is really a contract that you make with yourself during your lifetime. And that's the nice thing about a trust, is they're created during your lifetime. They are active while you're alive and well. They have provisions in them for what happens in the event you become mentally disabled during your lifetime. And then ultimately, it lays out all the provisions for what would happen in the event of your passing. And the thing that people like to focus on is that trusts are best known probably for avoiding probate. And I think historically, probate has been a four-letter word. People think of it as a bad thing, or they think that the state of Florida is going to take all your assets if you go through probate. And really, probate is not a bad thing. It really is just a process. And it's the process of administering someone's estate after they pass away. Now, potentially one of the downsides to probate is that it happens down at the probate court. And so when people hear court, they start to think bad things. And there's pros and cons though, because one of the advantages of having a court oversee the process is that you can be very certain that the I's are getting dotted and the T's are getting crossed, and that somebody's overseeing the process. And I'm going to simplify this a little bit, but there's really 3 steps in the estate administration process. And that first step is identifying and gathering all of the assets of the estate. So that could be checking, savings, money markets, CDs, mutual funds, investment accounts, stocks and bonds, retirement plans, insurance policies, annuities, and real property, as well as all the stuff that we have in our homes, so all of our personal property. So it's gathering up all the stuff and accounting for it. The second step in the process is making sure that if there are any creditors out there, that we have addressed those creditors, that we've paid them or that we've some way dealt with making sure that that creditor no longer exists. And of course, the number one biggest creditor that we probably all have is the IRS. So making sure that all of the final taxes are paid and that sort of thing. So that's all part of the second step in the process. And then the third step in the process is distributing the assets. So making sure that the people that you intend to get your stuff actually get your stuff. And I always smile when I do this, because families always like to start at step 3 rather than going through step 1 and step 2. Everybody's anxious to start at step 3. And I've been known to say that the 2 most common questions at a funeral are, what do I get and when do I get it? Mm-hmm. And sadly, most of the time, those 2 phrases are preceded by the phrase, I don't mean to seem greedy, but. So administration of somebody's estate has to be done whether you have a will or whether you have a trust. So even though you may avoid probate, which is that public administration process down at the court, even if you have a trust and you technically avoid probate, you don't avoid administration. There's still stuff to do when people die.
Okay. Now, I know some of that is like power of attorneys and things like that. Is there something specific maybe for the finances side of things for power of attorneys?
Sure. Now, a power of attorney is a very valuable planning tool because it works during your lifetime and is intended to appoint 1 or more persons, called your agent, to make decisions for you in the event that you're unable to make your own financial decisions, financial, legal, those kinds of things. That's called a financial durable power of attorney. And everybody needs one of those because we never know when we're going to be in a position where we might not be able to make our own decisions. Very, very important. They changed the law in Florida about 2011. So a little bit different than it used to be, but powers of attorney are very valuable planning tools. A lot of people think that they continue after death, but they don't. So when a person dies, power of attorney no longer works. And although we have powers of attorney for financial decision-making, we also have them for healthcare decision-making. So a healthcare power of attorney or a healthcare surrogate.
Yeah, I can see that those being really important, especially if something were to happen to you unexpectedly, let's say like a car accident or something that, you know, you're basically incapacitated, obviously the healthcare one, but then who's also taking care of your finances while you're not able to. So, and that would give them the power to do that. So. Correct.
And the alternative, if you don't have these powers of attorney, are we may find ourselves in the guardianship court. And so I always like to say that a guardianship is the worst kind of lawsuit because it's one that your family files against you, you get to pay for it, and you lose. Oh. So, and then we're down at the court. And so you know, is it cheaper to go to court or is it cheaper to do your planning? So it's always more cost effective to do your planning in advance.
So what are advanced directives? That's kind of a new term for me, but I wanted to get some more information about that.
So advanced directives really are those healthcare documents, the healthcare power of attorney, sometimes called the healthcare surrogate, which allows people to make everyday medical care decisions on your behalf. And it also includes your living will. And your living will, not to be confused with a living trust or a last will and testament, but your living will is a legal instrument that basically sets out how you would want to be cared for in the event you were unable to make your own healthcare decisions, and there was a very, very strong possibility that you were not going to survive, so that you either have a terminal illness, an end-stage condition, or you're in a persistent vegetative state, and the doctors have determined that there's no hope of your recovery. Your living will is your expression that says, this is how I want to be cared for. Take me off of life-prolonging procedures. Artificial respiration, artificial hydration, artificial nutrition, but please keep me comfortable, alleviate my pain, but allow me to pass away naturally. And people have strong opinions about living wills. People are either really for having a living will or really against having a living will. But it was Terry Schiavo who educated the world about living wills, because if Terry Schiavo had had a living will, we would have never heard of Terry Schiavo.
Yeah, that makes sense. I can understand that. So you have kind of, if we summarize what you just said, though, it seems like there's 4 important documents that almost everybody should have if they're not going to do a trust or do further planning. But that's, correct me if I'm wrong, like a last will and testament, a living will, healthcare power of attorney, and a financial power of attorney. Is there any more that probably, let's just say myself, who's a young, healthy person, you know, who has some assets and things like that, that would need to figure it out? We have those 4 documents. Are there any others?
There are actually. So there's a couple of other things that we talk to people about. One is called a pre-need guardian declaration. You don't need a guardian today, but if you found yourself in the guardianship court, it would pre-appoint those people that you might choose to make your financial and healthcare decisions for you. Some people want to make their wishes known regarding cremation or burial. And then also what we call a personal property memorandum, and that's for the distribution of your stuff. All your jewelry, your furniture, your collectibles, your heirlooms. And for people who are young like yourself, Amber, if you have minor children, you're going to want to make sure that in your will you address who's going to be the guardian of those minor children, and then who's going to manage the money for those minor children until they become sufficiently mature. So I'm not saying just turn 18, but become sufficiently mature that you would trust them to manage their own money.
That makes sense. I hear people all the time talking, well, not all the time, you hear it on the movies usually is, you know, they're getting their trust when they turn 25 or something like that. So it's not when they're 18, it's when they're later on in life and hopefully more mature to make those decisions. So how often should people be updating their estate plans? Once they get one done, when do they need to relook at it?
So that's an excellent question, because I think a lot of people kind of, once they've done their estate planning, they check that box and they say, yay, I got that done. And then they shove it in a drawer and maybe they don't think about it anymore. But really, your estate planning should be updated anytime there's a significant change in your life, or there's a significant change in the law, or your attorney gets smart about your lawyer's experience, or lastly, anytime there's a change in your legacy, the way you want to leave assets for the benefit of the people you love. At a minimum, we really recommend that people review their planning every 2 to 3 years, just to make sure that nothing significant has changed. And that doesn't have to be a full-blown redo. It's just a conversation to make sure that everything is still the way you'd want it to be. And what we've discovered is that the national average for updating is 19.6 years. And that's just way too long.
Wow, that is a long time. I would have thought maybe, maybe the average every 10 years, but 19 years? Wow.
19 years. So, and if you think about it this way, a lot of times people will do their planning after the birth of their first child. So they have a child and they go, oh, wow, I guess we need to be responsible and create an estate plan. So they create that plan after the birth of their first child. And then sometimes they don't even bother to update if they've had child 2 or child 3 or child 4, but they should do that. And then they don't really think about their planning again until those kids are now about 20 years old, right? So now the kids are grown and they're like, yeah, we don't need all of these provisions anymore in our planning. Maybe we want to appoint our kids to be in charge of some of the things that we had appointed other people for. And so at this stage in their life, maybe they're in their 40s or 50s, and then they don't think about it again until maybe after retirement. Where they go, oh, wow, now we're retired and maybe I should take a look at this again. And I'm always a little amazed when I meet people, though, who are in their 80s, and then this is the first time they've ever done their estate planning.
Yes, I would be amazed by that too, but I'm so glad they finally reached out to you. I think though, and I'm sure that you get this, the psychology of planning what would happen if you were to pass away is really hard to grasp that concept. And I think some people like to live in the belief that it won't happen to them, or something like that, when we're all going to pass away, unfortunately. We're not all eternal beings, but so, all of that needs to be addressed, but I think some people just don't like to ever approach that subject, whether it's with themselves or with their family members or whoever it is.
Sure, they don't. And I like to say that Americans are really optimistic. We always say, when I win the lottery and if I die.
Yeah. Should be the other way around. Yes, you're right. So in real estate, I obviously have to work with people that have inherited homes. And I know sometimes a lot of it can be, or I guess should say, even when somebody's purchasing a home and they're making the decision of how to hold title, right, for their property, that's an ownership type of structure. So do you have recommendations for not only maybe just real property, but other things about ownership of those assets?
Sure, absolutely. And I think it's important to point out that how you take title to any asset really is estate planning. It's part of your estate plan because it can actually direct what happens to that asset. So if you and I were to go out and buy a piece of real property together and take title as joint tenants with rights of survivorship, basically what that means is if something happens to me, you're going to own 100% of the property. If something happens to you, I'm going to own 100% of the property. So we have to make sure that that's really the outcome that we want. Otherwise, we might consider taking title to that property as tenants in common. So you own half and I own half. And then if something happens to me, my half goes to the people that I say in my will or in my trust, and your half goes to the people that you say. The downside to that, of course, is that we might end up owning a piece of property with people that we didn't intend to own property with. So I think that's important. I think there's a tendency for single parents to want to put their kids' names on property, and I really don't recommend that. And there's a lot of reasons having to do with liability, or in the event that child should get a divorce or have some sort of a catastrophic financial event in their life. So I'm not saying you should never do it, but you should never do it unless you've had the conversation with a legal professional about all the pros and cons of doing that. And then, of course, in the elder law arena, if we add our children's names to property of any sort, it could be construed as a gift. And then that may not be an outcome that we wanted either. So we just have to be really careful how we take title to property and how we name our beneficiaries on our other assets.
I mean, I see it all the time. People have done like quick claim deeds, added their parents or added their, children to it. And I kind of question, did you speak to an attorney to do it? And they're like, well, no, we just kind of went online and grabbed something. And I'm like, oh dear, like, are you sure you know the intentions of what you did, kind of thing. And so I think it's really important for them to have resources like you to reach out and at least have the conversation of if that's the best route for them to go.
I think that is important. And homestead property in Florida is kind of unique. Because Florida has some rules surrounding homestead property that not every other state in the nation has. In Florida, our homestead property is our castle, basically, so it's protected from the claims of creditors. But it has to be your homestead to be protected from the claims of creditors. And if you put a child's name or another person's name on that property and they don't reside on that property as their homestead, you may have lost some of those creditor protection attributes. The other thing that can happen in Florida is that your homestead property has some very specific rules about who you can leave your property to. So if you are a married person with no children or no minor children, the only person the law says you can leave your homestead property to is your spouse. So you want to make sure that your planning is consistent with that legal rule. Because if you go outside of that rule, then we get a result that we may not have expected. Where a spouse gets a life estate and the remainder interest goes to the children, the lineal children of the person. So we see a lot of circumstances where people didn't understand those rules and they end up with a result that they didn't expect.
Yeah.
So the general rule for husbands and wives anyway is that they own their property jointly. But again, if you have questions about that, you should talk with a legal professional.
Okay, I would agree with that. Now tell me a little bit about any restrictions on devise or descent.
Okay, so that's what I was talking about who you can leave your property to. So that's a fancy way of saying that Florida has some rules about who we can leave our homestead property to. That's the devise and descent part.
Got it. Okay, just those fancy terminologies there.
It is fancy terminology. So let's say that I own a piece of homestead property in my individual name, and that I have a spouse and I have a minor child. If I were to pass away and I didn't have a will and I didn't have proper planning, then automatically my spouse would end up with a life estate in that property and the remainder interest to all of my children, not just my minor child, but all of my children. So sometimes that can be a result that people don't expect, and it can land us in the guardianship court for minor children, of course, because minor kids can't own property.
Okay, I guess that makes sense. Yeah, I get you would have to delineate what would happen there. So is there anything else that you think that would be a frequently asked question by anybody that comes to you that gets asked?
So there are lots of frequently asked questions, as you can imagine, and thank you for addressing the pet issue up front, because that's a question that comes up. I think that I would say a lot of people say to me, well, Peggy, can't I do my estate planning myself? And of course you can. Just the same way that you can sell your own house, you can cut your own hair, you can examine your own eyes. I just say, I don't recommend it. I think that it's important to get good advice from a qualified professional, because if we go online, we may learn only a small piece of what we need to know. And unless you can really understand the big picture and know all of the nuances, and there's so much to know, as you know, Amber, it's just hard to know everything. So I personally don't think that estate planning is a do-it-yourself project. I think it's worth getting professional advice and assistance, much as I wouldn't try to sell my own home, because I appreciate the professional advice that comes along with that activity.
Well, I think what you touched on is that there's nuances to each individual case. And the same thing applies to real estate, is that every single transaction for me, even if it seems like it's clear, cut, and dry, there's always some type of little tiny thing that, okay, now we have this speed bump we have to get over. And the experience and the education that we have to try to get us over that with not just killing the whole transaction is what makes it important to have a professional on your side. So the same thing goes here, is that we may do our own will, but I'm forgetting this whole section, you know, or this little tiny detail about my life that I didn't realize that you would have asked the question and picked up on and made sure that that was in the will. So I think that that's really important to have a professional do it over doing it yourself.
Well, and I think that brings us back to the idea that the professional's job is to teach the questions that you didn't even know that you needed to ask. And I think that that's where it's really, really valuable. So there are lots of frequently asked questions. Our website has about 150 short videos answering frequently asked questions. So for people that have additional questions, they can visit the website at hoytbryan.com, or certainly we do a lot of educational workshops, and we would invite people to attend those, or to sit down with us one-on-one to answer questions.
All right, and then just so you guys know, that's Hoyt, and then Bryan is BRYAN.com, so hoytbryan.com. And that would be a great way to reach out to you guys. I know that you are based out of Oviedo. Do you serve all of Florida or just Central Florida? What's your kind of range of service?
Well, fortunately, we are licensed to practice law in all of Florida. So for folks that want our services that live remotely in Florida from us, we certainly can help them, and we do have clients all over the state. I would say primarily, we serve the Central Florida area because we do need to meet with people at least once in person, even if it's for the signing ceremony.
The drive-by signing ceremony.
That's right.
All right, Peggy. Well, it was such a joy to have you on, and you provided a lot of information to us, and hopefully we got some questions answered to people. I checked on Facebook. We had a comment just saying thanks for offering these Zoom events from Marcy Gordon. Her husband is also in law, but so it's glad that she's peeking in and taking some interest into our topic. And hopefully if I get any feedback of any other questions, Peggy, I'll pass them along to you. And thank you again so much for joining us today. And I hope you have an awesome day.
You too. I hope you have a great day. It's a beautiful day out, and happy May Day.
Oh yeah, it's May Day. I forgot about that. Cool. That's exciting. Something to celebrate for today.
That's right.
Yeah. Well, you take care, Peggy. Nice to see you. Thank you so much.
You're welcome. See you later, Amber.